Hello and welcome to our last panel of the day, a panel that is remarkably distinguished, indeed we might say illustrious. And it would be easy for me to make that case, the case for their distinction, by reciting to you a long list of each panelist's accomplishments. But this panel also has what I think is the virtue of being a remarkably humble panel, that nation only. I am delighted to honor that request, mostly because without further ado, I'm going to introduce our first speaker. Our first speaker is Professor William Eskridge, who teaches at the Yale Law School.
Joan, thank you for that really gracious introduction. And I always appreciate Federalist Society events because they're always the best-run events in the world, as those of us who got picked up at the airport promptly on time will always attest. So it's always a pleasure. Now, I'm not exactly sure what our panel is supposed to be about. It's supposed to be about tradition at some level or another, and the role of courts. And these topics might be at war with one another, and we might have different efforts at synthesis. So let me present my effort at synthesis, and I am going to focus on tradition, and then segue at various points into the role of courts. And I want to think constitutionally about the 14th Amendment. The 14th Amendment, where the Equal Protection Clause and the Due Process Clause are located, at least as applied to the states. These are highly open-textured provisions, but they are constitutionally binding on the states. So they conceivably cut across a wide swath of state laws that restrict people's liberty or treat people in different ways. But those clauses have never been interpreted as broadly as they might be. So one topic that is worth reflecting on, judges have done this, law professors, and now Federalist Society is what role might tradition play in providing perhaps a limiting principle or constraining principle for the judges applying these very open-textured provisions. And I think that is as difficult a question as it is important. And I want to use as my text for thinking about that two decisions you probably know much about. One is Bowers and Hardwick in 1986, where the Supreme Court, over a four-justice dissent, upheld the Georgia consensual sodomy law against a right of privacy attack, opinion by Justice White, who I'll say to the earlier panel is a justice who evolved in a conservative direction in the not-too-recent past. The second case I want to talk about is parents involved. That's the decision last year where Chief Justice Roberts, also for a divided court, struck down school district desegregation plans that included race-based criteria. He struck that down as inconsistent with the Equal Protection Clause. Now, how does tradition cut in these various cases? Well, there are three things I want to reflect upon. One is what counts as tradition. A second is at what level of generality do we or should we think about tradition? And third is what about the Burkean point of view, the evolution of tradition, or the way in which tradition might evolve. So the first question is what counts as tradition? And I think there is a conundrum at the center of tradition here. Because tradition is often used just as misty history. Tradition could be the common law. Tradition could be the original discussions. Tradition could be the legal developments, including cases as well as statutes, at the time of or following the legal discussions, et cetera, et cetera. But tradition can also be precedent, because both the Equal Protection and Due Process Clauses have generated literally cartloads of precedent. Is that not also tradition? And Bowers and parents involved, it seems to me, are cases where there is a war among the different sources of tradition in those cases. So, for example, in Bowers versus Hardwick, the dissent relied on more recent tradition. They relied on precedents from Griswold and Eisenstadt and Stanley and Moore and other cases that had recognized a broad right of privacy. And the Supreme Court majority used tradition as a reason not to expand these precedents, not to overrule any of the precedents, but to say we're not going to expand these precedents any further. Now, conversely, in parents involved, the court majority declined the dissent's invitation to use tradition as a reason to limit the expansion of precedents like Gratz and other affirmative action striking down precedents, not Grutter, which upheld, but decisions like Gratz. And the argument of the dissent was that we have a tradition in the United States, starting with Reconstruction statutes and moving up into the Brown era, affirmed by Supreme Court opinions from Swan versus Charlotte Mecklenburg on, where race, when it's used in a remedial way, is evaluated under more lenient criteria. And the court in that case declined to rely or to accept the tradition argument as a reason not to expand these recent precedents, like the Gratz precedent, of course, that arose here at the University of Michigan. Okay? I don't propose to resolve these conundrums. I merely propose to give them to you. Here's the second one, and this is even more troublesome. And that is, when you talk about tradition, at what level of abstraction do you talk about tradition? Because tradition is multiple. Tradition also might be plastic. Now, one way you can think about tradition, our history, is at a very high level of abstraction. And this indeed is the way the tradition was handled in Parents Concerned. It was a very high level of abstraction, the idea of color blindness, that we have a tradition of color blindness, a tradition of looking past color. Fair enough. The dissent, on the other hand, said that there's another tradition at a high level of generality, and that's the tradition we have of integration. And that tradition also is important. It's at a high level of generality, but it's in some conflict. Look at Bowers versus Hardwick. The dissenting justices looked at tradition at a much higher level of generality than Justice White did. The dissenting justices said that the tradition in our country is a tradition of autonomous choices as regards important life decisions. The majority responded with an intermediate level of generality, say, no, the tradition should better be set at decisions to marry and to raise children. Now, you can also look at tradition in these cases at a much lower level of abstraction, where Justice Scalia says, what is the specific practice that tradition might endorse? Okay? Now, there, the Bowers majority had another response to the dissent. The Bowers majority said that tradition supports us because there are millennia of moral teaching in the Anglo-American law that homosexual sodomy has always been criminalized, said the majority. In the parents involved case, the dissent looked at the lowest level of abstraction. The dissent's argument was that race-based remedial laws existed in Reconstruction. They were accepted as consistent with equal protection concepts, and that those laws, according to Justice Breyer's dissent, have a long history from Reconstruction to President Bush's statute, No Child Left Behind, which also has race-based criterions in that statute, as Justice Breyer pointed out. But here's the problem there, and that is that even tradition at this concrete level is manipulable and hard to deal with because often there is no precise parallel between the tradition of the past and the problem of the present. So, for example, in Bowers versus Hardwick, sounds like a pretty good argument that millennia of moral teaching in Anglo-American law have always criminalized homosexual sodomy, until you look at the evidence. And everything is contextual, and everything should look at the evidence. The term homosexual sodomy did not even exist before the 20th century, and is not used in a statute until the Texas statute, 1973, that was struck down in Lawrence. Sodomy laws in the 19th century, when the 14th Amendment was framed, did not a single one of them, apply to oral sex, which was the conduct that was involved in the Bowers case. And indeed, even in the middle 20th century, most sodomy laws didn't apply to oral sex between women. Women were basically left out of sodomy laws, at least as regards homosexual conduct. And if you want to look at the reported sodomy prosecutions, in other words, the ones the framers might have known about in 1868, there were no reported cases outside of the rape or public sex context until well into the 20th century. So what is it, the tradition that's being created or recognized in Bowers versus Hardwick, even at this very concrete level? You can do the same exercise in parents involved. Justice Breyer's very impressive use of tradition there is responded to by Justice Thomas. In his concurring opinion, Justice Thomas said, yes, but today is different. In Reconstruction, we had just ended slavery, and so the remedial use of race-based classifications is more justifiable in the 1860s than it would be in the new millennium. Okay? I could go on and on for many hours, but I won't. The point, it seems to me, is very simple. The use of tradition whether it's at a high level of abstraction or a low level of abstraction, is like looking out over the crowd and picking out your friends. And if there are not enough friends in the crowd, it's sending your law clerks into the crowd so that they can be picked out. Now, there's yet another way of looking at tradition. And this is the way that was recognized in Justice John Harlan's dissent in Poe versus Ullman, on which Charles Freed, the Solicitor General in the 1980s, played a very decisive drafting hand. And that is the recognition that tradition evolves. And it evolves not just through precedent, but the commitments engendered by general constitutional purposes are clarified and applied to new circumstances over the years. So what about a concept, a middle-level concept called evolving tradition, which might have advantages of workability, advantages of recognizability, and possibly even advantages of democracy? Now, the objection to evolving tradition, of course, is that it doesn't give the judge sufficient legal or democratically based criteria by which the judge exercises her constitutional common law authority to interpret the equal protection of constraining it. And my main suggestion is that as you look at evolving tradition, in other words, the idea that Justice Harlan had, that you should be particularly attentive to the evolution and due process clauses. I think that's a solid objection, but I think there are ways evolving statutory-based traditions that are reflected by federal superstatutes, such as the Civil Rights Act of 1964, and state statutory convergences over the years. And indeed, if you look at tradition in that way, which is legal and is democratic, statutory convergences, and provides criteria for judges, keeps them out of trouble, etc., it actually provides you a very interesting way to reconcile Bowers versus Hardwick with the decision that overruled it in Lawrence versus Texas. And indeed, you could even defend Justice White's opinion in Bowers versus Hardwick. Because in 1986, there were 26 states, and recently the D.C. government, imposed upon by Congress, that still in 1986 made consensual sodomy a serious crime. Almost all of them were felonies. In the period after Bowers versus Hardwick, between 1986 and 2003, half of those states and D.C. Revoked their sodomy laws, at least as regards to consensual behavior. So one can argue, actually, I know Justice Kennedy didn't say this, but one can argue that Bowers versus Hardwick was a defensible decision, at least in not striking down based upon a privacy rationale, and that Lawrence versus Texas reflected a different kind of judgment, and one that was not necessarily simply a judicial willful judgment, but a judgment that was based upon a statutory common law process. Now, I think Justice Kennedy's concurring opinion in Parents Involved offers the same analysis. Remember, Parents Involved had a majority opinion as to much of it, but Justice Kennedy only concurred in the result as to a number of issues. And what Justice Kennedy, the key vote, and therefore the law as to some issues today, suggested in Parents Evolved, is that districts can diversify. Colorblindness is a purpose of the 14th Amendment, but so is diversification, said Justice Kennedy. With Roberts agreeing on the first point, Breyer agreeing with him on the second point. But Justice Kennedy says, if you're going to try to diversify using race-based criteria, you're going to have to satisfy a deliberative requirement that shows me and shows the rest of the court that you've looked at other alternatives and that you're invoking the least restrictive means. Now, what about the marriage issue? We were also asked to talk about the same-sex marriage issue. It does seem to me, and I'm going to have to shorten my analysis just a little bit, but it does seem to me that this same kind of common law process does give us a guidepost how to deal with same-sex marriage, and also gives us a guidepost that justifies how we actually did deal with different race marriage. Because remember, for most of our history, just as same-sex marriages have not been recognized, different race marriages were also not recognized in most of the United States, and indeed they were a crime in Virginia for most of Virginia's history as a colony and as a state in the United States. Tradition strongly works against recognizing different race marriages, at least as a constitutional matter, as well as same-sex marriages ditto. Precedent muddies up the matter in some respects. From Brown on for different race marriage, from the sex discrimination cases, and possibly even Lawrence for same-sex marriage. Justice Scalia tells us in the Lawrence dissent that now that Lawrence is the law, that same-sex marriage is the next step. I wouldn't bet that he'll vote on that, but that is what he argues as a matter of logic. So what's going to happen on these issues? Well, as you know, and if you don't, I'm going to now tell you, the Supreme Court in 1967 did strike down different race marriage statutes, statutes that abolished or criminalized or prohibited different race marriages. It's interesting the Supreme Court did not do this in the 1950s when it decided Brown versus Board. And I think the reason is statutory constitutionalism, state statutory convergences, and I might also add federal superstatutes such as the 64 Act and the 65 Voting Rights Act, both of which came right before Loving versus Virginia. In 1951, or 1954, when Brown was decided, there were 30 states that barred different race marriages. After Brown, and by 1967, that number was down to 16 or 17. And that was when the Supreme Court struck them down. It seems to me the lesson for same-sex marriage is painfully obvious. There's no reason for Justice Scalia to worry that the U.S. Supreme Court is going to impose same-sex marriages on the United States. One state has now recognized them, and a number of states have recognized civil unions, domestic partnerships, and a number of alternatives. The U.S. Supreme Court would be foolish, and they're not foolish, to take a case and use any kind of case as a vehicle for imposing same-sex marriage as a matter of constitutional meaning. The U.S. Supreme Court is going to stay out of the issue, except possibly for choice of law purposes, and that is good for America as well as good for the Supreme Court. Where this is going to be battled, and where it should be battled, frankly, is at the states. This is called the Federalist Society, n'est-ce pas? Well, you guys are right. You've always been right. And you're right on the issue of same-sex marriage. It's going to be battled state by state. And different state judges are going to interpret their state constitutions. Well, we might ask how. How should state judges interpret their state constitutions? And my answer, I'm mainly a professor of legislation, so this might explain the answer. And the answer is you follow legislative initiatives. So, for example, you don't have to worry in Michigan whether your state Supreme Court is going to impose same-sex marriage on you. It's not, I'm going to tell you. And it has nothing to do with methodology. It has only to do with Michigan is not ready for it yet. There's no legal basis in Michigan for this kind of adventure to transpire. Where we have had adventurous judicial decisions have been following legislative leads. So, for example, legislatures and governors, in a couple of cases in New Jersey, Massachusetts, and Vermont, adopted limited recognition of domestic partnership unions before the highest courts of all three of those states required greater equality. In Massachusetts, it was same-sex marriage. In New Jersey and Vermont, it was essentially ultimately civil unions. In Hawaii, which was the first case back in 1993, the Hawaii Supreme Court, in response to legislative rebuff, pulled back and ultimately declined to recognize same-sex marriages. In Hawaii now we have reciprocal beneficiaries, which is what the legislature offered. Do the courts have any role to play other than following legislative leads? Conceivably, and again, not in Michigan, but in states that have anti-discrimination laws, states that have repealed their sodomy laws, states that have enacted hate crime laws on sexual orientation matters. In other words, where the legislature and the people have already taken the lead in creating conditions for possible equal citizenship for gay and lesbian citizens. So this is a small list of states. They're clustered in the Northeast and the West Coast. At some point in the next 10 years, they will also start clustering around the Great Lakes, so watch out, Michigan. And it seems to me the main role of judges here is and should be not to usurp the issue, but the most that judges are going to be able to do, and probably the most that they should do, is reverse the burden of inertia. What does that mean? Well, if there's no constitutional litigation, it's obviously up to the legislature. It is very difficult to enact things through the legislature, and it is triply difficult for a traditionally despised minority. You not only have to go through the various veto gates that the legislature has, it's going to engender terrible controversy because there are two sides to the issue easily, and any kind of conflictual issue is very difficult. And then, frankly, there remains in America an enormous amount of anti-gay prejudice and indeed hatred. And some of that actually is harbored by legislators as well as judges. So it is triply difficult. It's by no means impossible, but it's triply difficult to achieve these legislative things without some kind of push, even in friendly states. And this is essentially what happened in Massachusetts, Vermont, New Jersey, and Hawaii. In all of those states, the courts didn't finally determine same-sex marriage. Instead, they reversed the burden of inertia. They said the burden is no longer on the gay and lesbian couples to go to the legislature and get some crumb. Instead, the burden is on the legislature to provide them with something, and then to provide a justification for whatever it is providing or it's not providing, marriage, unions, et cetera, et cetera. And in all of these states, or at least Massachusetts and Vermont for sure, New Jersey, probably Hawaii for sure, in all of these states, high court interpretations of their state constitutions were immediately reversible by the people. In Massachusetts and Vermont, it would have required 2 legislatures in succession to vote by majority, and then a legislative referendum to confirm that. Did not happen in either state. In Hawaii, it was simply one session of the legislature, and it was adopted by a referendum of the people that stopped same-sex marriage in Hawaii. And that, it seems to me, is a critical difference between same-sex marriage litigation in the states and in the federal government. Federal Constitution, as was said earlier in this day, is at a high level of generality and is almost impossible to amend. That is not true of most state constitutions. Most of them are much more detailed, much more recent, and much easier to amend, which means that any kind of judicial action is almost never going to be the final word. But that's mine.
Thank you very much, Professor Eskridge. Next, we will hear from Professor Tom Merrill. I guess the least I can do is give the fancy chairs that all these people hold. So I will amend with respect to Professor Eskridge and say that he is the John A. Garver Professor of Jurisprudence at the Yale Law School. And Professor Merrill is the Charles Keller Beekman Professor of Law at Columbia Law School. Those of you who have had me for constitutional law, I hope you won't hold it too much against Professor Merrill that he taught me everything I know.
Thanks very much, Joan. I'm supposed to be the big proponent of traditionalism on this panel, and so it is with not a little guilt that I tell you I'm not going to stand up here and defend traditionalism today. Instead, I'm going to concentrate on the other half of our charge, which is to consider popular constitutionalism. And in particular, I want to address the question of whether when tradition runs out and fails to provide a meaningful resolution of contested issues of constitutional law, whether we should turn to popular constitutionalism as a way of filling the gap. Popular constitutionalism, as some of you may know, is all the rage now in academia. It started more or less with Bruce Ackerman at Yale, who came up with the idea of constitutional moments, which are sort of upsurges of law and become the basis for a new constitutional understanding, which in effect is a de facto amendment of the Constitution. Other scholars like Larry Kramer at Stanford and Mark Tushnet at Harvard have argued recently that the Constitution should be interpreted more by the popular sentiment opposed to current constitutional regimes. Those sentiments then get enacted into law. People themselves rather than elite judges. And so popular constitutionalism is very much the rage. Interestingly enough, and this goes back to the first panel of today, we have, I think, a recent controlled experiment in popular constitutionalism, which I think provides some interesting lessons about how and when popular constitutionalism might work in interpreting contested issues of constitutional law. I'm speaking in particular about the backlash to the Kelo decision. Kelo, as you know, resulted in a 5-4 decision in which the Supreme Court said there's no per se prohibition on using eminent domain for economic development. But the court went on to invite state legislators and state judiciaries to develop, as a matter of state constitutional or statutory law, more restrictive conceptions of when eminent domain could be used. The invitation was received wholeheartedly. I think according to the latest tally, there have now been 42 states that have adopted some type of legislative or popular response to the Kelo decision, in each case cutting back on eminent domain to some extent from what the Supreme Court authorized as a matter of federal constitutional law. And perhaps more interestingly than the 42 is that 12 states considered popular referenda in the November 2006 elections, which would restrict the power of eminent domain. And in 10 of those states, the public voted by comfortable margins to, in effect, impose as a matter of state law, in some cases constitutional law, in some cases non-constitutional law, a per se rule against using eminent domain for economic development. So we have a situation where the highest court in the land, the U.S. Supreme Court, goes one way, and the public goes the other way in very short order. And this is, I think, an example of popular constitutionalism in action. Now, why might popular constitutionalism be an appropriate way to resolve the question about the limits on the use of eminent domain? One reason, I think, is that the judiciary has largely failed in the process of developing meaningful restrictions on eminent domain. I don't have time to go into the whole sorry tale here, but let it be said that the U.S. Supreme Court, over its history, has encountered this issue about a dozen times, never once seeing fit to strike down an exercise of eminent domain as violating the public use requirement of the federal Constitution. And the court never articulated any sort of consistent set of principles as to what might or might not violate the public use requirement. State courts haven't really done much better. If you look at state judicial jurisprudence on the issue of public use, you'll find a significant number of decisions invalidating exercises of eminent domain. About 1 in 6 state appellate court decisions strike down the use of eminent domain as violating some kind of state public use requirement, but there's no consistent theory, no consistent conception of what public use means that emerges from these cases. So the judiciary has tried and failed to really articulate some kind of jurisprudence of eminent domain, or when eminent domain should be used. The deeper reason for that, I think, is that the issue is one that involves conflictual values that are very difficult to, they're very incommensurate. It's very difficult to sort of weigh these values against each other. On the one hand, you have sort of a strong argument for a broad power of eminent domain in order to overcome holdout problems that permit assembly of parcels of land in new configurations or footprints, which would facilitate some kind of project which is in the public interest. This affirmative rationale for eminent domain really has no stopping point. There's no natural limitation on public projects or projects used by the public, as opposed to other types of projects that may just produce positive externalities or other types of advantages to the public. Juxtaposed against an argument in favor of broad eminent domain is a strong argument against using eminent domain willy-nilly. Every time you use eminent domain, you in effect expropriate a portion of the value that people have in their property. You compensate them for the fair market value of what's taken, but you take away the subjective attachment that they have to the property without providing any compensation for that. No one's really been able to figure out how to measure that subjective value in any meaningful sense. And so every exercise of eminent domain is unfair. It takes the property of a few people, takes away their subjective valuation without compensation for the benefit of the many. And this argument against using eminent domain has no stopping point. In the opposite direction, it's true of every exercise of eminent domain, whether it be for a public project or a private project or what have you. So we have these conflicting values underlying eminent domain. We have the judiciary. So the suggestion might be, let's use popular constitutionalism. And indeed, why stop with state legislatures or local legislative bodies coming up with principles for limiting eminent domain? Let's go right to the source and ask the people themselves whether they think, what they think, failing to come up with any kind of legal principle that would consistently resolve these cases, where they think the balance should be struck in using eminent domain. And there's been some interesting recent theorizing about this. what I find most interesting is some literature. Adrian Vermeule at Harvard is the main author here I'm thinking of, who has tried to analyze the jury, and in particular utilizing the so-called Condorcet jury theorem, which is a proposition of mathematics that basically says that many minds are more likely to get things right than few minds or one mind. And so more precisely, if you have a group of people who are asked to make a decision on a particular question, and the members of the group are at least on average more likely to get the answer right than wrong, then the more people in the group, the larger the group, the more likely you are to get the right answer. The usual illustration of this is a bunch of people guessing the number of jelly beans in a jar. So if everyone in this room were to guess the number of jelly beans in a jar and put the guess on a slip of paper, the average the guesses would be all over the place. So the Condorcet jury theorem suggests that maybe if we have some kind of public referendum about eminent domain or other similar contested constitutional questions, we might get closer to the right answer, however we're going to define right answer, than if we let smaller groups, like say 9 elderly lawyers wearing black robes, vote on how the decision ought to come out. And maybe popular constitutionalism is in fact the way to go. The literature on the Condorcet jury theorem, however, suggests that there are some limiting principles in when the principle works and when it doesn't work, and that we'd have to also pay attention to those. One of the limiting principles is that the voters have to be, on average, more likely to get the right answer than the wrong answer. If you flip that around and say that the voters are more likely to get it wrong than to get it right, then the more people you have making the decision, the more likely it is that the decision is going to be wrong. So you have to be pretty sure if our guesses would be very close to correct to the number of jelly beans in the jar, whereas if we individually try to make a guess, that the basic condition that people are on average more likely to get it right applies in a given situation. You also, another condition that the theorem requires is that every member of the decisional group has to be exposed to the same body of information. So this works for juries and appellate judicial panels and things like that, because they're all exposed in a very controlled way to the same amount of information. But if you have a group of people that have very disparate information, the theorem doesn't necessarily apply. A third condition is that the voters have to decide independently. They all have to make their independent decision. There can't be any log rolling, there can't be any vote buying, there can't even be any jaw boning back and forth trying to persuade each other about the correct answer to the problem. These three conditions suggest to me that we ought to have some reservations about using the public through referendum to resolve questions of constitutional law. To take the Kelo case, for example, it's pretty clear to me that before the Kelo case was handed down, probably less than 1% of the public had any idea what eminent domain means. Somebody in this morning's panel mentioned that Kelo was an educational moment, that suddenly everyone now did understand what eminent domain means. But I'm not really sure that their understanding of what eminent domain means after this little moment of publicity was anything that would constitute enough information in order to make us confident that they were more likely to have correct and incorrect answers about how to strike the balance between when to use eminent domain and when not to use eminent domain. There's a general problem here of rational ignorance. It doesn't really make sense for most people to inform themselves about the conflicted policies underlying eminent domain or when it might be used and not be used because eminent domain is very likely to affect most people. It's a rather unusual exercise of governmental power. Another problem that the Kelo episode suggests is one of decision-making subject to biases and heuristics that distort people's decision-making. The opinion polls that came out after Kelo, I think, are particularly indicative of the potential problems here. A number of polls asked people what they thought of the Kelo issue. And by the way, the opinion polls show that people oppose Kelo by percentages running from 80% to 96% opposition. The highest negative vote on any public policy issue that pollsters have ever encountered. But many of the polls asked people what they thought of eminent domain by describing it as a seizure of property by the government. Seizure implies lawless, sudden, non-deliberative sort of action by the government. It's not surprising that people would think that seizures are bad things. Other polls, quite astonishingly as far as I'm concerned, failed to inform the people being polled that eminent domain requires the payment of compensation when property is taken. So people were in effect being asked whether they thought that expropriation of property was a good idea for the benefit of the Pfizer Corporation or something like that. And I would be rather alarmed if the American public didn't think that was a bad idea. So the high percentages are being driven here in part by the way in which the issue is being framed by the pollsters. A third problem, which I think, to my mind, is perhaps the most important, is that we have to distinguish between the public response to a problem when it's posed as an abstract issue and their potential response when it's proposed in the form of a concrete case or situation. I would venture to guess, as a general matter, that when people are asked about issues in the abstract, they're more likely to respond in a polarized fashion or in a very one-sided fashion. So, for example, if you ask people whether or not they think abortion should be lawful, my guess would be that people would line up in a kind of barbell-shaped distribution, with many saying, no, it should be unlawful, and others saying, no, it should always be lawful. But if you ask people to decide whether in a particular case, which is described in some detail, what ought to happen, you would probably get something that looks more like a bell-shaped curve distribution. And I think I would surmise the same thing is true of eminent domain. I actually don't just have to surmise that. There's some recent social science work which I think confirms this. Two of my former colleagues at Northwestern, Janice Nadler and Sherry Diamond, have recently undertaken an examination of all public opinion polling on the Kelo issue. And the following passage in particular struck me as quite revealing. They say, the reaction depends on what is taken, whether land or a business or a home, and how it will be used. At one extreme, using eminent domain to take vacant land and run down buildings for a school garners almost uniform 88% support and minimal outright rejection 7%. Part of this strong support might be explained by the minimal harm to the owner because of the nature of the property taken. When low-value homes are taken for the same purpose to build a school, support drops from 88% to 33%. Thus, a large percentage of the respondents reject the idea of taking homes even for an important purpose. Another source of strong support for the use of eminent domain in this situation is the good use to which the land would be put. Note that although using eminent domain to take low-value homes to build a school garners the support of 33%, this support drops to 7% when low-value homes are taken to build high-value homes and only 4% when low-value homes are taken to build a shopping center. On the other hand, when the purpose of the building is, if the purpose of building a shopping center is juxtaposed to the taking of vacant or rundown buildings, then 55% of the respondents suggest that eminent domain is appropriate. I would emphasize that this data seems to suggest that people are engaged in an implicit balancing. What property's been taken, what's the use going to be that its property is being put toward. And the more data you give them, the more specifics you give them, more concrete the case is made, the more nuanced the judgment becomes. And I think this would be important in structuring any kind of public input on the resolution of constitutional problems. So what sort of tentative conclusions might I draw from these reflections on the post-Kelo experience with popular constitutionalism? First, I think it's pretty clear, at least to me, that popular referenda are only appropriate if the issue is one that has proven to be resistant to resolution using conventional tools of legal analysis. I don't think anybody would propose that we use referenda to decide whether or not slavery should be abolished or whether or not we should have free speech on political questions or anything of that nature. If the polity has settled on certain fundamental constitutional principles, by all means have the judiciary enforce those principles. Don't put them up to a public vote. Secondly, I think it's important that whatever the voting unit is on the constitutional question, that the issue has to be one that the members who are voting care enough about so that they can be expected to have gathered a meaningful amount of information on the issue. Somebody earlier in the session, I think this morning, talked about a referendum on whether or not pigs should be kept in certain small cages. In the state of Florida, for example, I think an issue like that probably is not one that enough people care about to adequately inform themselves, and one would be suspect of the meaningfulness of using a referendum. Similarly, asking people whether or not the Dormant Commerce Clause should apply to taxation is something that's unlikely to reach meaningful results. So it has to be something that's salient to the public, that the public cares about. I think some of Bill's issues about same-sex marriage and so forth would clearly qualify under the salience requirement. These are things that people understand very well and have an opinion, informed opinion about. Thirdly, and this is sort of related to the second, I think it's very important to structure the size of the jurisdictional unit in which the referendum takes place, again, to maximize the possibility that people, of the likelihood that people will have meaningful information about the question. And here I would cautiously endorse the idea of using referenda to decide contested issues of public use for economic development projects, provided the referenda takes place at a small enough local level so that we can have a fair degree of confidence that the people voting in the referendum know enough about the project and about the people that are going to be displaced and so forth to render an informed decision about it. So to take, for example, the New London case, I think it's fairly reasonable to assume that the people living in the city of New London understood what the Fort Trumbull redevelopment project was about. They knew about the condition of the property before it was going to be taken by eminent domain. They had some sense of whether or not the proposed project was likely to succeed or fail, and they would have some knowledge about the people who were going to be displaced, including the homeowners. And they would, I think, to a significant degree, identify with those people because the people voting would also be homeowners in the same community. They would therefore understand that if eminent domain can be used to take these people's property, perhaps that's a precedent that would allow my property to be taken sometime in the future. Lastly, I think we'd have to be very careful about the way in which the issues are framed through referenda. A lot of the initiatives that were talked about this morning are ones where interest groups write the proposals and determine the timing, and that can result in kind of slanted or biased responses to the proposals. We'd have to have, I think, some mechanism for trying to assure that the proposals are framed in such a way that they don't elicit unduly emotional or one-sided results. But I think it's certainly worth experimenting about. The judiciary hasn't been able to figure out how to decide when eminent domain should be used and when it shouldn't be used. The political process that was jump-started by Kelo is all over the map. The 42 states that adopted various laws in response to Kelo there's no rhyme or reason or consistent theme to the types of reactions that they came up with. And I think in these circumstances, some kind of significant experimentation with local referendum to resolve the eminent domain issue is certainly worth considering in a situation where tradition and originalism and other traditional tools of constitutional interpretation have simply run out. Thank you.
Thank you, Professor Merrill. Next, we will hear from Professor Reva Siegel. She is the Deputy Dean and Nicholas Katzenbach Professor of Law and Professor of American Studies at the Yale Law School.
Hi. So this is an interesting experience for me. I don't often come to Federalist Society conferences, and not being a regular, I assumed that I was going to actually speak on what it was that I was asked to speak on, and so I probably will be the only person here who's going to talk about Glucksberg. But I'm going to work my way up to it and then beyond it in a way that I hope takes up the questions of traditionalism that the panel is framing and will, at its outer reaches, touch on issues of popular constitutionalism that are obviously in play here. So I happen to have an interest in the very different ways in which we talk about the Constitution and talk about history in interpreting the Constitution. Just as much as we have ways of summoning the Constitution as text, as structure, as doctrine, we also have many forms of talk about the relevant forms of history that bear on questions of constitutional interpretation. So perhaps for this group, most obviously, there's the history of the Constitution's ratification, the stuff of originalist interpretation. There's also, as Bill was pointing out, the materials of doctrine, the chain of interpretation, which creates history reaching from the point of the Constitution's adoption to the present, and which entangles in various of its turns all kinds of other attendant history along the way. There's collective memory that's relevant to the ways in which we interpret the Constitution. Think about the role of our sense of national political history, of the Revolution, slavery, the Civil War, or of fights over the court in 1937 or Roe. All of this, of course, bears on our sense of the Article III power. Custom is also another form of history that bears on the way in which we interpret the Constitution, a sense of the history and traditions of the nation, its norms, its ways of life. And of course, that's the topic of this panel. I at least want to, at the gateway, point out that there's some tension between understanding the Constitution as a compact and understanding it through the lens of custom, that it is, in fact, quite a different thing to understand the Constitution's authority as deriving from an act of lawmaking and residing in a text, and understanding it as arriving out of custom or a way of life, history and traditions. There are moves to try to shrink this difference or distance between the two understandings of relevant pasts. We can treat tradition as an expression of democratic will, especially if we consider or try to adduce tradition by considering institutions of preference aggregation for evidence of a tradition's existence or its meaning. So you can look at what it is that other, say, state legislatures have done. I think this is a theme that will run through the panel. But it still is a stretch in the sense that tradition offers no specific text to interpret, and results obviously in various forms of its own ambiguities. And it also blurs what we count as the relevant community of constitution makers to consult, who are tradition's authors. So how is it then that Chief Justice Rehnquist and then subsequently Justice Scalia have come to embrace the Glucksberg history and traditions test? One way of understanding this arises out of a case in 1997 in which the court upheld Washington's law prohibiting assisted suicide as not prohibited by the 14th Amendment's due process clause, substantive due process law. So one way of understanding the Glucksberg doctrine and Chief Justice Rehnquist and ultimately Justice Scalia's convergence on Glucksberg's history and traditions test is to locate it in a several decades struggle against Roe. You can think of the Reagan campaigns, the ways in which the concerns reverberate through litigation of Bowers, through the Bork confirmation hearings, Scalia's opinion in Michael H. and Gerald D., and finally, the Rehnquist opinion in Glucksberg, and see and understand why it is that ultimately Justice Scalia will embrace the Glucksberg standard as a way of disciplining substantive due process law, which I think we understand he's not so great a fan. I'll just read you the language, relevant language from the Rehnquist opinion. He announces there that substantive due process analysis has two primary features. We've regularly observed that the due process clause specifically protects fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty such that neither liberty nor justice would exist if they were sacrificed. And then he goes on to observe that we need a careful description of the asserted fundamental liberty interest. This descends from Scalia. I'm not going to take the group's time, except to say that this test, in fact, innovated on prior law, even Scalia's own opinions in the Michael H. case and in White's opinion in Bowers in trying to sort of, instead of framing this area of law as either the ordered liberty or the history and traditions, really making it a joint, you need both. And it wanted to be an exclusive account of the law. But the court itself didn't follow this. And so while the decision has never been reversed, it's not managed to reshape the law in the way that its authors hoped, and it's become, in fact, alive, importantly, in dissent. Justice Scalia's exasperated objections to the court, to Justice Souter, to Justice Kennedy, and others of his brethren. Now, in the remainder of my remarks today, I would like to take a look at what it is that Glucksberg wants to do and to think about its attractiveness along a couple of different lines. It certainly has a lively life at the moment as a tool for critique, and it's always possible, given a certain outcome in November, that there might be the votes for it to really have a much more lively place in the court's 14th Amendment jurisprudence. And so the question becomes, what kind of an undertaking is this? I thought about exploring the tensions between the understanding of constitutional authority in originalism and in this idea of traditionalism, the sort of tension between the Bork and the Burkean view of the project, emphasizing differences between them. But I thought in the end that I found more interesting to explore, and I should say, if you're interested in thinking about that question, there's a wonderful paper that Mike McConnell has written, sort of situating this, that is definitely worth a read. It's the Baum Lecture in the University of Illinois Law Review. But I decided that what would be interesting to do on this occasion is to think some about a certain kind of affinity in aim between the originalist project and the form of traditionalism that appears in the Glucksberg line of cases. And that is that they both share in common the aspiration of cabining judicial discretion, right? That's certainly a concern that has attended this entire, the elaboration of this entire body of law. So there is here an account of a history and traditions jurisprudence set forth that aims to be objective as a standard and leach out of the process of interpreting and extending the 14th Amendment's due process clause judicial value judgments. The idea is that this is going to be objective. It's going to restrain the judge from his or her own engagement, internal normative engagement in the project. And I wanted to just observe in passing that there is, first of all, I think actually Bill was raising this, a series of questions about the feasibility of doing this. That is to say, about whether this project can be made mechanical. And there's writing, Treibendorf and others, along the lines you've heard today, worry about tradition at what level of generality or particularity. So long as there's that degree of ambiguity, there's discretion that can be employed or deployed by the decision maker in a way that will allow value to guide the decision of the case. There's concern about the forms of relevant evidence. You can think about debates over a case like Roper and know what do you consult as evidence of this tradition, which relevant decision makers might be there to vindicate it. But there's also just an interesting question about the normative attractiveness of this project that really snagged my attention. That is to say, why would you want judges in the business of trying to simply determine an existing tradition as a reason for simply restricting democratic processes that varied from it, independent of the value that it might embody? It struck me as a very strange enterprise. I thought of just some examples of it. For example, at common law, abortion was legal until quickening, which is the first perception of fetal movement, and around the 4th month. And at some point, states decided that they were interested in criminalizing the practice, and this represented an enormous deviance from an existing tradition. Now, you could think of bad or good reasons for treating this as that is to say, the abortion decision, as a liberty protected by the 14th Amendment or 5th Amendment. But in order to think about that question, you'd have to do it from an internal values-based perspective. And the idea that you could just determine that from the outside struck me as passing strange. Another example of a common law rule is the master or the father's property interests in his children's labor, their service. At a certain point in time, we have child labor laws that come along and begin to change what was otherwise universally the common law rule and universal practice. And it's definitely experienced as entrenching on I don't know, we use the language of privacy, freedom, property interest, whatever. It was doing all of those good things and resisted along those lines quite passionately. In order to think about whether law should be there, you would need actually, I think, someone from an internal value-based standpoint trying to determine the rights or wrongs of this, not something mechanical. Otherwise, bottom line, in a democratic federated polity, it doesn't seem like there's much of a role for this kind. Include this branch of my observations here. I'm dubious about the feasibility of a mechanical, objective jurisprudence of the kind that Glucksberg is talking about, and I don't understand it as a normatively attractive use of judicial power in a federated constitutional democracy. That is to say, the kind of value-free judging that is aspirationally pointed to in that decision. So the question becomes, does that kill the project, or is there a case for value-based judicial enforcement of history and traditions? I'm sort of mulling about this question of enforcement of tradition. It has to be internally normative. So, as I'm reading and thinking about Glucksberg, a case that I actually hadn't spent so much time thinking about, and in thinking about that question, I decided to explore examples of history and traditions jurisprudence in another context or two, and so I'm going to just mention them briefly for you to, along with my panelists, expand the range of possibly relevant cases here. So the two cases I'm going to talk about briefly are the court's 1983 case Marsh against Chambers, in which the court upheld the practice of legislative prayer under the Establishment Clause, and also its 95 decision in Lopez under the Commerce Clause, which I'm sure all of you are profoundly familiar with. So the Marsh case is an interesting case in which Chief Justice Burger is essentially saying that it ought to be constitutional under the Establishment Clause to for states to open their legislative proceedings with prayer, and in so doing, or in so announcing, he is coming to a result that seemed, presumably to everyone on the court, completely at odds with the Lemon test then prevailing, which the dissent argued at length, and the majority just never mentioned. Instead, the opinion emphasizes both original understanding and the unbroken practice of legislative bodies in having their proceedings start with a prayer. And it's hard to make the originalist argument really govern as a matter of positive law, in the sense that this was Nebraska and the First Amendment is written, Congress shall make no law abridging, and it's just not, it's obviously an extension of the original understanding, and the opinion is leaning quite heavily on this history and traditions argument. What struck me as so fascinating about it is that this case is decided in '83, right after Reagan comes to power, in a campaign that is passionately criticizing existing jurisprudence and cases like Lemon for having undervalued the role of prayer in civic life. And I just have from the Republican Party's platform, it calls, we support Republican initiatives in the Congress to restore the right of individuals to participate in voluntary non-denominational prayer in schools and other public facilities. Reagan had put school prayer in such a way as to bend doctrine dramatically, certainly not an understanding of the tradition that was shared by all members of the court, but one that happened to accord with a very successful, I mean profoundly successful, public mobilization concurrent with the time of the decision. My second example is the Lopez case in 1995. Amendment forward, etc. So my point being here that here's a history and traditions argument advanced. So here we have the first Supreme Court decision for a half century after the New Deal, striking down a law of Congress as exceeding its power under the Commerce Clause. And in voting to strike down this statute, neither Chief Justice Rehnquist nor Kennedy O'Connor, even Thomas, really invoke original understanding as the basis of their decision. Instead, and there's different opinions, and because our time is short, I'm not going to take the time to go through them, although I'm sure you have in detail. I'll just focus on the Rehnquist opinion. He attests loyalty to New Deal precedent, but then proceeds to narrow it in a way that, as you know, stimulates protest from a certain wing of the court, and emphasizes that Congress can regulate economic activities that substantially affect interstate commerce. And to Souter and Breyer's objections that education is an economic activity, and from the standpoint of economics would be human capital formation is understood as an economic activity. Instead, the Rehnquist opinion begins to emphasize that economic activity has to be interpreted in light of the history and traditions of federalism in the post-New Deal period. So again, the meaning of economic activity is not derived through the lens of economics, but instead it's derived through the lens of history and traditions. If, again, I had more time, I could situate this opinion in its sort of surrounding context. Suffice it to say that the Lopez case was argued on Election Day of 1994, the day the contract with America succeeded in retaking the Congress, on a message of returning government to the people and ending big government in Washington. And when the decision came down, it was reported entirely in the frame of this contemporary mobilization. So once again, you have a case in which there's a body of doctrine that points to a certain result, and in fact, the court doesn't go the direction in which stare decisis would point it, invokes an idea of history and traditions, which happens to concur, isn't shared by all members of its interpretation of the tradition is not shared by all members of the court, but happens to accord with contemporary vibrant political mobilization that's succeeding in making itself felt in the representative branches of government. So what do we make from these examples? In a very short period of time, I'm just going to close with a few points for thought or conversation thereafter. I remain skeptical about both the feasibility and desirability of a value-free account of a history and traditions jurisprudence. I can't really address the question of whether those who are critics of the court's substantive due process jurisprudence should put all their eggs in the Glucksberg basket. That's not my question. But it is striking to me that there are a variety of circumstances of doctrinal elaboration in the last couple decades which have really given lively conservative voice to the history and traditions, a modality which is very different than the original understanding modality. And I'm using this opportunity to sort of admiringly engage with this. And to say that this practice is in fact quite commonplace in our constitutional jurisprudence, that is to say this value-engaged relationship to tradition. And it's commonplace from a positive standpoint. Our constitutional jurisprudence is rife with it, and it may well serve very important public functions. Because of the time issues, I will simply put on the table for conversation the possibility that this way of talking about constitutional change could function as a kind of normative bridge across normative communities. We know there are multiple of them in the United States. For the Federalist Society, there's also ACS meetings, and there are many groups that never converge in this kind of fora. So we know that we're a nation that is normatively heterogeneous, and yet we share in common a commitment to a text of a constitution, a history, and a variety of traditions which are powerful, meaningful, and compelling to many of us. And making claims on those history and traditions may be ways in which we can engage in conversation with each other about matters over which we passionately disagree. I don't think that a value-free jurisprudence, that a value-based traditions and history and traditions jurisprudence is a good thing unmoored. I think if it were to be implemented in the examples I gave, it was actually embedded in something like the I think what we've heard phrases of statutory convergences, and Bob Cover used the phrase jurisdictional redundancy, that there are multiple federated and horizontally separated system of government has a lot of seats of government which can speak norms. And through that process, we can see ways in which the people over time can speak their values in ways that may be read by courts. This is a dynamic that a number of people on this panel is talking about. I think that history and traditions is a tool, a piece of the conversation as much as the Constitution's text is in that enterprise, and possibly a rich one. To the extent that's so, I'm not imagining that history and traditions is going to be used in such a way that jurisprudence is going to either completely diverge from the felt understandings of the American people, nor completely mirror them. That is to say, I don't think that courts simply mirror public opinion. There's reasons why conservatives or progressives mobilize out of concern about courts run wild, because courts do have a degree of relative autonomy and the ability to use their authority to teach and to make law change in ways that simply can't be read off the face of majoritarian sentiment. But in the end, I understand courts to be, in a constitutional democracy, responsive institutions, and institutions that both understand themselves acting from a role standpoint to be accountable to the American people, and an institution that the American people also know how to hold to account. And with that, I'll stop for now.
Thank you very much, Professor Siegel. Lastly, we'll hear from Professor Keith Whittington. He is the William Nelson Cromwell Professor of Politics at Princeton, so a law professor where there are no law students. I'm not saying whether that's a good or a bad thing.
Thank you. So I want to take on a different facet of the multifaceted text we were provided to initiate this panel, and the issues raised under it, and pick up in part on some of the issues that Professor Eskridge dealt with as well, and in particular talk about the question of the extent to which the court, and here I want to talk about courts generically, so not simply the U.S. Supreme Court, but often state courts playing a particular role, but also lower level courts and judges, and not simply those courts sitting at the top of the appellate system, whether the state or the federal appellate court system, but whether courts play a leadership role, or should play a leadership role, can play a leadership role, do play a leadership role in defining constitutional values within the American political system, and what's the relative role of courts versus other kinds of institutions, or perhaps the people at large, in thinking about constitutional values and constitutional rules more generally. And in thinking about this question, I want to spend a little bit of time thinking about empirical issues associated with this question, and a little less time thinking about normative questions associated with this issue. So let me start with thinking a bit about the empirical question of just how much leadership role courts, in fact, do tend to play in shaping constitutional values and articulating constitutional rules as against other kinds of political institutions that are also engaged in the process of trying to articulate constitutional rules and interpret the constitutions that we have. So as we know, and I think is certainly true, courts are not as responsive or as accountable as other institutions within the political system. They are not as immediately responsive to public opinion in general. They can be somewhat less in touch with public opinion than elective executive branch officials or than elected legislatures. Likewise, courts, no matter how they're structured at the state or federal level, are generally speaking less accountable for their decision making than what we generally have in legislatures and executives in the American system. So courts are, generally speaking, more independent of the people than other kinds of institutions, and I think that's a reasonable starting point for thinking at least that they are less responsive and less accountable than the other institutions that we're facing. Nonetheless, courts are generally tied into the broader political system. It's easy to overestimate and overstate the degree to which courts are simply outside of politics or radically independent of other political actors or the political system more generally. Whether we're talking about state courts or federal courts, courts are tied into the political system in a variety of ways, not least judges emerge out of political systems, that they rise to the bench through politicized processes, whether that's an appointments process of the type that we see at the federal level, or whether that's an electoral process of the type that we see in many state systems. Judges are political creatures. They're chosen for political reasons. They're chosen with political ideas and objects in mind. And ultimately, judges do not stray very far from the ideas and commitments and values of those who tended to appoint them. There are obviously exceptions. There are idiosyncratic judges. There are mavericks. There are people who shift some over time. But as we think about the court system as a whole, we think about individual courts as a whole, as multi-member bodies, courts are generally quite tied into the political system. Moreover, judges share common political and social sensibilities with others operating at the time. To this degree, judges are elite political officials like other elite political officials, and they tend to share similar sensibilities and similar general views about the kinds of political problems and social problems that are confronting society and government officials more generally, and that tends to lead judges to behave in ways that are comparable to the ways that other political actors are behaving given any particular political problem, rather than in ways that are radically divergent from the ways that other political actors are thinking about sets of problems. So judges come at these problems with a set of perspectives that are certainly different than the set of perspectives and incentives that drive other political actors as well, and that will lead them to some different solutions and some different actions on some of these issues as well. But it's important to recognize the commonalities between judges and other kinds of political actors that tend to tie judges into the political process more generally, and generally speaking then tend to lead judges in basically the same general direction as other actors within their given political system, whether we're talking in a federal system in which Supreme Court justices are basically moving in the same direction as elite national political actors at that given moment, or we're talking state judges who are responsive to the same kinds of political pressures in their particular jurisdiction that may well not match up with judges in other jurisdictions and political actors and public opinion in other jurisdictions, but within their own particular jurisdiction, judges are likely to be on more or less the same page with other political actors operating within that jurisdiction as well. So given that basic connection between courts and other political actors, what are courts doing as they exercise the power of judicial review, and just how autonomous might they be, and under what kind of circumstances might we expect them to act somewhat independently of other actors? And one thing courts do is they tend to work on the margins of politics. So rather than making important decisions right at the center of politics and controversial political issues, they tend to operate more generally on the margins of politics and make decisions, especially decisions with a fair amount of autonomy to them on the relative margins of politics. And margins occur in a variety of ways. So one type of margins of politics that judges can work with a fair amount of autonomy in are on low salience issues. So issues that other political actors simply don't care very much about, issues that the general public doesn't care very much about. Judges have a fair amount of discretion about how they resolve those kinds of issues, and they have a lot of flexibility about how to make constitutional decisions in those kinds of areas, generally speaking. An awful lot of constitutional law actually looks like that. That is, we tend to think of judicial review as being intrinsically important. We think of constitutional law as being intrinsically important. But from a political perspective, a lot of constitutional law is boring. It's not very important from a political perspective. No one's going to win or lose elections based on that stuff. Most politicians don't care what the court does with most of those decisions. So judges have a fair amount of discretion about what they do on a lot of constitutional issues that they, in fact, confront. Secondly, courts can also work with some degree of independence on the margins when there are divisions within larger political coalitions. So to the extent that the political system is fragmented or their political allies are fragmented, when there is no particular majority on a given issue. Judges are going to have more independence to push in some directions than they might otherwise have if other political actors or public opinion tends to be lined up in a relatively solid way behind a given particular decision. So when public opinion or political actors tend to be lined up in a fairly clear way, that is the kind of way that we would expect when we think of the counter-majoritarian difficulty, judges tend not to have much independence, and they tend not to run up against that. Judges tend not to be counter-majoritarian in that kind of straightforward way. On the other hand, if other political actors, if political coalitions tend to be fragmented, if public opinion is highly divided, judges then have more space to operate. They're more likely to come in and make decisions and stake out some ground precisely because the space is relatively fragmented in that context. And somewhat different version of that, though, is thinking about how federal courts might intervene in the context of states. And Professor Eskridge points to a particular example of this, but this can be generalized, of thinking about states shifting over time, whether it's in the context of homosexual sodomy statutes or whether we think about same-sex marriage statutes. But we can also think about this across a variety of other type of cases where the Supreme Court's much more likely to intervene in constitutional issues that are going to impact state-level legislation when there's relatively few states involved, either because intrinsically relatively few states have ever adopted those kinds of statutes or relatively few states are invested in the particular policy that the court is striking down, or because states have shifted over time of the sort that is arising in this particular example, but certainly arises in lots of other examples as well, where you see states gradually moving such that by the time the Supreme Court intervenes, the policy is now within a minority of the nation. A smaller number of states are now committed to it. That's when the Supreme Court swoops in and wipes out the minority of states. But this court is relatively unlikely to reach into a constitutional controversy when most states are lined up against it. And you look across the broad range of constitutional decisions the court has made across its entire history, that tends to be the general pattern of how the U.S. Supreme Court operates. It waits until a policy is in the minority, or it looks at policies that are in the minority within the states at the moment, and then the court strikes at those kinds of policies. It rarely acts against policies that are actually in the majority, although there are occasions. Having said that, the court sometimes makes mistakes about thinking about the political climate. That is, sometimes it perceives that there is a trend or a trajectory that's emerging about the direction in which the political climate is moving, and it doesn't anticipate correctly quite how far that climate's going. I think the court's death penalty decisions in the early 1970s, for example, likely reflects that, where states and public opinion seemed to be moving toward eliminating the death penalty. The court jumped into the middle of that controversy, and there was a large backlash against the court. It seems likely that the court incorrectly anticipated where states were going, making a similar calculation there that they were making in other kinds of cases as well. Roe v. Wade itself may well reflect a similar kind of calculation by the court, where you have a liberalizing tendency, generally speaking, in the states, although one that I think had largely stalled out by the time the court actually intervened in Roe. But the court might well have looked at that and thought that they were on the side of history in terms of the trajectory in which things were moving, but they wound up a little bit in front of the curve in terms of where politics and policy actually was heading. So let me finally just say a bit about normative issues associated with questions of the court exercising this kind of leadership role. I start from a perspective of originalism, as Professor Primus mentioned earlier. I've spent books and articles defending an originalist theory of constitutional interpretation, as well as an originalist grounding for the exercise of judicial review, and that's how I tend to think about this issue as well from a normative perspective, and it makes sense for the court to have as its starting point thinking about what the Constitution requires from an originalist perspective before thinking about what actions it ought to undertake, and thinking about striking a particular law down. But even taking from that perspective of basically an originalist approach to thinking about issues, I just wanted to note a couple of cautions about evaluating cases. One is that the mere fact that a court's decision is controversial in a moment should not by itself give us pause about what it is that the court's doing. We should expect the court to issue unpopular and controversial decisions across a range of cases. That by itself, that's not necessarily a signal that the court has done something wrong or has made a mistake or is ruling on bad principles or problematic principles. We expect that constitutional rules, when they're initially adopted at least, should generally be popular. That is, our constitutional rules emerge out of a popular system of adoption such that they were at some point endorsed by popular majorities, although there's some interesting qualifications to that to the extent that constitutional rules might be part of a package deal. It may well be possible that a given constitutional rule was in fact never that popular, but we bought into it because we bought an entire constitution at a single sweep. But generally speaking, it's entirely possible that constitutional rules are initially popular at the time that they were adopted. It's possible that the popularity of those constitutional rules might decline over time such that a court that continues to enforce that constitutional rule is running up against public opinion that's increasingly skeptical of the constitutional rule itself. But it seems equally likely, perhaps more likely, that the particular implications or applications of a general constitutional rule may well be unpopular, that people may not like a particular application of a rule or a particular implication of a rule, even if the constitutional rule itself is relatively popular. The devil, of course, is in the details of figuring out what the particular implications are of a given constitutional rule. But again, the point I want to make here is simply the mere fact that the court has issued an unpopular or controversial decision shouldn't itself be taken as a signal that the court has done something wrong or is creating new values in a way that should be problematic or assuming a leadership role that should be seen as problematic. But instead, we have to get behind that in thinking about what kind of constitutional rule the court's enforcing and how it's going about that task of enforcing it.
Thank you, Professor Whittington. I had hoped to have time to give our panelists some time to respond to one another, but we've had a full and rich discussion by which one might read long. And I want to give you the chance to ask questions. And besides, we've all had a chance to stand up, which is good for late afternoon. So if anyone wants to ask a question to our panelists, please come to the microphones. Yes.
Hello. Hi, this is Jim Worsnop from Florida State University. To what extent do you guys think the decision to grant certiorari in Heller was driven by the ascendancy of the gun rights movement and the collapse of the gun control movement in the past, 5 years or so? And to what extent do you think that will color any opinions that come out of the case?
I think the decision to grant review was driven by the perception that there was a conflict in the circuits on this issue. But the gun case is something that I was thinking about as I was listening to my co-panelists up here. One of the big issues from this kind of Glucksberg tradition enforcing perspective is what determines the agenda of the court. Why is the court enforcing majoritarian conventions on outlier states in certain areas and then letting the states experiment with novel approaches in other areas? The language of the Constitution doesn't seem to provide a very rock-solid explanation, since by definition the substantive due process cases aren't really controlled by the language of the Constitution. The gun control case is an interesting one because it is controlled by, there is language in the Constitution squarely on point, but for decades and decades, it was not really seen as a judicial issue. There was no, significant litigation headed toward a Supreme Court showdown on whether gun control is constitutional or not, and the justices seemed perfectly happy with that implicit decision to keep it off their agenda. I think it was really forced on their agenda by the circuit split.
Yes.
My name is Brian Barnes. Professor Eskridge, you talk about the problem of identifying the appropriate degree of generality in our application of tradition, but I wonder to what extent tradition itself or original understanding may give us some guidance in making that determination. Well, the thought might be that to some extent, the way courts have always understood the meaning of the 14th Amendment in a particular context would give us some guidance, would tell us how, in a particular case, a court ought to understand the 14th Amendment.
Okay, well, I'm afraid that doesn't help as much as it might, because the court over different generations and over different justices has set the level of generality inquiry very differently. So, for example, Bowers and Glucksberg set it as a more specific level of generality, whereas Griswold versus Connecticut sets it at a very general level of generality, and some of the incorporation decisions, because preceding all of these are decisions incorporating various of the Bill of Rights against the states, and many of them are set at very high levels of generality. Does the right to counsel inhere in ordered liberty, et cetera, et cetera. So I don't think, I honestly don't think the Supreme Court opinions are really very helpful at setting the level of generality question. Here's the way I would say that a judge should think about it. It does seem to me, I think the key question is, how much has changed, right? So if we had a recent constitutional amendment, there have not been very many of them, but if we had a recent constitutional amendment that specifically addressed a whole cluster of issues, and then as a corollary, there were other issues that arguably came within it, I would say, you know, low level of generality should be probably your inquiry. That doesn't predetermine how you're going to vote, because it might depend on exactly what the evidence is. And then I would say, but if you're talking about 1868, it seems to me, if you're going to do the low level of generality, the more concrete stuff, but if circumstances have changed, it either becomes worthless or extraordinarily indeterminate because so malleable and so plastic. And as evidence, you know, I cite the evidence that I provided. You know, I think Justice White is a brilliant justice. I don't think he's a dishonest justice. I don't think he's a lawless justice. I think he's an interpretive justice. But I think he was incapable, even someone as smart as that, in translating the concrete stuff that he had before him, or was able to search. Everything that I mentioned in my verbal presentation was in the statute books. It could have been found. And I found it, and it was easy to find. And so it's not like Justice White didn't work hard or wasn't smart or couldn't have found it. It was just complicated, right? And if I were arguing the other side, I could come up with, you know, I'm sure better stuff to support poor Justice White. So that's the difficulty, is that law is not easy. And a lot of these legal technologies do run out in the hard cases.
Yes.
Hi. Daniel Danishred from NYU. Professor Siegel, you mentioned the economic distinction that Rehnquist brings up in Lopez. And I was wondering if you might be able to comment a little bit more about what you think he actually meant when he was referring to something as economic in nature. And if you could also comment on the Raich decision. And actually, this is open to anyone, if anyone else has something to say.
Well, my point in raising this is just, first of all, Lopez. Thank you. Lopez claimed fidelity to the New Deal cases, but it's a matter of dispute on the court whether it was acting in fidelity to them. Let's just say that it read them with the view that they needed to be constrained a bit. And this gloss on the New Deal cases, namely that Congress has the power to regulate interstate commerce when it's regulating economic activities that substantially affect interstate commerce. The economic modifier was used to knock out both the Gun-Free School Zones Act and also it became the basis for objecting to the civil rights remedy of the Violence Against Women Act in the Morrison case that followed shortly thereafter. And the question is, first of all, it's a matter of doctrinal, the common law method that this restrictor was added, but then the question is, how do we tell what's economic? It's sort of resonant of the old direct, indirect effects test. How do we decide? And once the test exists, you need to come up with an interpretive methodology to decide what counts as economic activities. So you could consult economics for deciding that, and if you did, you could certainly see education as an economic activity. Seen through the lens of economics, the activities of education are, creation of literacy, promotes social wealth, right? But where the opinion goes is to this history and traditions reading of our federalism to give content to the adjective economic. And I have views about whether this is the appropriate use, that is to say, whether the federalism cases, the Commerce Clause cases, this area of structural constitutional law needs heightened judicial scrutiny of the kind that it was given in this line of cases. From my standpoint, it doesn't, but it's an intelligible standpoint to me that it does, and this is a way of developing it. I'm just observing that its ground, there's a particular sort of line of justification. It's a claim about history and traditions. It's entirely values-based. It's not the history and tradition doesn't provide an answer. That is to say, there were plenty of people who predicted completely otherwise. I guess for all of you who've learned constitutional law, since you all came up in a world with Lopez in it, I'm aged enough that I taught constitutional law classes before the case came down, and no one believed that the case was going to come out that way based on their sense of the prior case law. But now we live in a world in which it's now become reasonable. The baseline has changed. That is actually itself the result of an incredibly multifaceted, powerful, and effective movement to alter the way in which we think about what's truly national and what's truly local, which had its expression in Congress as well as on the court. And this opinion was a part of that. So in the end, I don't believe that there's an answer in the stuff of the constitutional interpretation that gives you a value-free answer. Constitution rightly understood. And that's a very different perspective about where constraint is coming from.
Your question about race, I think, is very good. Because race, that's the California medical marijuana case, but it was raised on a Commerce Clause ground rather than a privacy ground at the Supreme Court level. And I think that's a wonderful case to show the unfortunate contrast between tradition and precedent. Because as you remember in that case, Justice Thomas dissents based upon a traditionalist original meaning understanding of the Commerce Clause, right? Interestingly, Justice Scalia concurs and goes along with upholding the application of the Controlled Substances Act, California. And I think Justice Scalia really hits the nail with his head when he openly admits, I'm very attracted to what Justice Thomas is saying. But since the 1930s, and frankly before that, that has not been the approach the court has taken. This has been precedent, which is law, etc. And then what Justice Scalia goes off on, and this is your question, Daniel, is Wickard versus Filburn. And Justice Scalia says there's a case on point, close enough on point, reasonably on point. Wickard and Filburn, that's the farmer case. And Scalia says Congress could reasonably have concluded, like the Congress in the 1930s, that even homegrown marijuana will contribute to some marijuana market that the Congress then wants to regulate in the Controlled Substances Act. And I think that's a real smart opinion, but it does reveal some of these ambiguities and tensions.
I'd just like to point out that there was a popular constitutional way of resolving these cases, consistently Lopez, Morrison, and Raich, which would have avoided some of these verbal gymnastics about traditionalist understandings of economics and so forth. And that was simply that Congress had made no statutory findings of an effect on interstate commerce in either the Lopez statute or the Morrison statute that were before the courts, whereas it had very extensive findings in the Controlled Substances Act. So if the court wanted to adopt a clear statement approach, which is a version of a kind of popular constitutionalism, which says that we're going to interpret the Constitution in partnership with Congress, and we're going to make Congress speak clearly before we permit regulation in this area, it could have come out the way it did in all three of those cases, consistent with that approach.
Can I just add that there were no findings in Lopez, but the Morrison case, there were actually
in the legislative history.
Yeah, there.
And if we're going to be picky about this.
That's what a clear statement rule
Right.
is.
All right, okay.
Yeah. Just to chime in here, the one other thing I'd say about Lopez is that we've been talking about different modes of constitutional interpretation, but one thing to think about in the split between Scalia and Thomas, so when you think about Lopez, you think about Raich, is that, while Thomas has a clear, a nice textual analysis, which is hard to dispute on the text, Justice Scalia, and a decent original understanding, and Justice Scalia doesn't join, and one might ask why, but you also have to think about institutional responsibility. So, had Justice Scalia, imagine there are 5 votes for Justice Thomas's position, and now we're, bombed back to an 18th century economy. I just don't think the court was willing to do that, however attracted they were to some normative commitment to originalism tradition. So I wouldn't say it was necessarily driven by command for precedent, but more for sort of institutional concerns.
May I tell a 2-minute anecdote?
Yeah, 2 minutes, and we got to take this last question.
So every 2 years, I bring my class to a Supreme Court argument. We visit with Justice Scalia afterwards. The last 2 times we've done this, the students have asked him to talk about Griswold versus Connecticut. After the obscenities die down, then the students ask him, well, Justice Scalia, would you overrule Griswold today? And the first time they asked him that, which was a couple, 3 years ago, he looked at him, he said, nah. And I almost fell out of my seat. I said, why on earth not? And he said, it's been there for so long. So that's from the horse's mouth.
I also think that the Bork hearings had something to do with Griswold's status today. That the direction, that Glucksberg is actually an effect of this, that the critique of this whole line of cases shifted off of Griswold and went after Roe straight on, and that there was some response, if our themes are popular constitutionalism.
It's worth noting that Thomas is not the only option on Raich or Lopez, right? Thomas is the extreme outlier on how far to go. I think the correct one, right? So you just get rid of the New Deal. But the court wasn't going there. You could have gone less far than that, and Rehnquist lays that out to say we go back to the New Deal and we get rid of the Great Society, and that gets you. And that gets you the dissenters' result in Raich, as well as getting you the majority opinion in Lopez. And that's the Rehnquist solution, which at least is a reasonable compromise.
Okay, we have time for one last question.
Matthew Morley from Ave Maria School of Law here in Ann Arbor. I'm interested what any or all of you have to say on this question, professors. Professor Hills in the first panel referred to his Westphalian theory of rights, the idea that, like the Peace of Westphalia, you nationalize or constitutionalize the rights on which there is a deep national consensus, rather than jumping in and trying to resolve a controversy that's fairly split, as some of you referred to. And at the same time, in a later panel, I think one panelist referred to the idea that appointed judges, in his opinion, could be more professional because they're looking to their legacy, which is what professionals do, as opposed to trying to please the public, which he thought elected judges might be more apt to do. In light of those ideas, I was wondering, should courts think of their task in terms of legacy, what they're leaving to the society going forward, or in terms of where their decisions will be situated in the current consensus or political order, regardless of a judge's political philosophy? It seemed a drawback of legacy could be ego, might enter into it too much, but a good aspect is you think really carefully about the implications of decisions. And it seemed looking at consensus too much, a drawback might be that you're looking too much at public opinion, but perhaps a benefit might be you don't destabilize society for conservative activist reasons or liberal activist reasons. I hope that question doesn't take on too much.
Well, let me say 3 brief things. Thing number 1, I do think the judges' comparative advantage and their job description is that they have to deal with legal materials. And so I think that should be what judges do in all these cases. That's why I would emphasize, if they're going to talk about consensus, I do believe they have to look to legal materials. If you're going to talk about tradition, I think you should need to look at legal materials and not opinion polls. And I think if you're going to talk about evolving consensus, I think you should look at state statutory convergences, federal statutes, and so on, et cetera. So that's number one. Number two, it does seem to me that your question still has some bite because much of the Constitution is open-textured. And it is binding on us, and it strikes down things if they're not consistent with it. And so, for better or for worse, what judges are doing, certainly at the federal level and often at the state level, is a common law constitutionalism. You know, they can say whatever they want to say, but that is what they're doing. And that's probably what the right to privacy is, and it's probably what the Equal Protection Clause has done as well. And it does seem to me there that it's both probably safer for judges and better for the country for judges not to stick their necks out very often. And when they do stick their necks out, and this is my third point, is they should bide their time and they should do statutory interpretation or other doctrines that allow for legislative, popular, executive response. That's the advantage of clear statement rules. That's the advantage of reversing the burden of inertia, is that I think the biggest mistake of cases like Roe was that a lot of people justifiably felt that the Supreme Court was trying to close a conversation prematurely. And I think technique can be just as important as timing in that respect.
I can't help it. If you're interested in seeing any relatively recently done history of Roe's reception on this question, Robert Post and I have a piece called Roe Rage, Democratic Constitutionalism and Backlash, and it does work through the material, and it raises at least a question whether, in fact, people were responding to the court's reasoning or something else. And it being the hour it is, I'm not going to even remotely go there, except to invite you to take a look at the piece. It was in the Harvard Civil Liberties, Civil Rights Review last fall. Cass Sunstein also has a piece on backlash there. He has another in Stanford as well. But there's a good chunk of material that sort of digs through the actual years afterwards and asks the question, is what happened itself a response to bad decision-making or something else?
Okay, I'd like to thank all of our panelists. And now I have an announcement that should be of interest to you because it involves food and drink. So for those of you who are attending the banquet, please board the buses at the Monroe Street exit. Now, there are no windows, and I'm hopelessly directionally impaired. So I shall not point. I shall just read. Out the doors, straight, turn left, doors on the right. I hope that makes sense. As you did last night, there will be volunteers outside to guide you there. Hope to see you all.
Thank you so much for being a great moderator.